Okay, welcome back. I'm doing another video on the Rittenhouse trial today. Since the last video, a lot has happened. First of all, there were closing arguments. There was the jury instructions on Friday, and then today is Monday, and they had the closing arguments today. Since the last time I did a video, I wanted to just briefly update everybody on where the trial's at and summarize what's happened. And then I wanted to answer a few questions that people had been asking me. And then finally, I wanted to get into a very brief summary of what I think this case is about and what's going to happen. All right, so firstly, let me just briefly say that on Thursday, I think it was, they had the final witnesses. The defense called three pretty inconsequential witnesses. One of them was a video commentator, one of them was a police officer who just testified about bullet casings, and the other one was a video expert who testified about the sequence of shots, and was pretty objective and fair, so it really didn't, I don't think that moved the needle, any of these witnesses moved the needle at all. But I wanted to mention something about the jury instructions, which is what came next. So, as I previously said, there were 6 charges on this case, and let me just pull that up real quick, but basically the charges were 3 counts of doing something recklessly, in 2 cases reckless homicide, or reckless endangerment to public safety rather, and then the third one was basically the reckless homicide. And then there were 2 intentional counts. There was, I'm like multitasking, so I hope you can, I hope I'm not being too distracting, but basically the 2 intentional ones were 1 count of intentional murder and 1 count of attempted intentional murder. And yeah, so those are the 6 counts. Now, the judge did dismiss one of the counts today, and that was the minor in possession of a firearm. And we will get to that. I really don't agree with that decision by the judge. But that's where we're at. So with those 6 charges, the jury instructions, basically what jury instructions are is they are a set of protocols that the judge works on and ultimately delivers to the jury that tell them precisely how to look at the issues and how to make decisions about the issues, and ultimately what elements need to be determined to be present for the jury to convict the defendant or to acquit them. And, when I first started out in law school, it wasn't clear to me that crimes had elements. I mean, I knew a lot of this stuff, but you really don't think about these details. So let me just tell you this: crimes have elements. Theft, the taking of something that belongs to another without. Well, we'll leave that. Just taking something belongs to another person, and you intend mentally to keep that item permanently. You intend to permanently deprive the owner of that item. Okay, that's 3 elements, just to keep it simple. And what if this jury finds that you did 2 of the 3 elements? Are you guilty of theft? Well, no. The jury has to find that for any given crime, the person has, has met the each element that's in there, and that each element individually has to be proven beyond a reasonable doubt. If there's a doubt as to a single element, then that element is not proven, and then therefore that crime is not proven. And we will talk about lesser included offenses. We talked about that a little bit, I think, the other day, but lesser included offenses are basically just, let's say there's 3 elements that make up crime B, and let's say to make it a more serious version of crime B and make it what we'll call crime A, you have to have an additional element. Let's say the additional element is you injure somebody during the, whatever. So if crime A is the more serious crime, the lesser included is a less serious crime that has at least 1 less element. But the less serious crime, the traditional rule is the less serious crime cannot have additional side elements that make it a different kind of thing than the original higher crime. So the jury instructions were interesting. The biggest disputes that I remember coming up during the jury instructions were a dispute over provocation, which we're going to talk about a lot today, a dispute over the lesser includeds and which ones could be and couldn't be included, a dispute over some self-defense language, and a dispute over the firearms charge, which resulted in a dismissal of that count today. The jury instructions do two basic things. As I mentioned, they tell the jury what the elements of a crime that they need to find were proved, but they also do more basic things. They say, well, when you first get together, select a four-person, select somebody to coordinate the jury and figure out, where everybody's at. They include things like, what if two witnesses say something different? How do you determine who's telling the truth? They include generic language like, you can use common sense and you can infer intent based on somebody's actions. And it includes a lot of things like that. So it's usually like a 30 or 40 page packet of pages, and they're broken up by section. So it's not like it's an entire full page. It's usually just a few sentences, honestly. And it's a fairly quick read, notwithstanding the length. And what I would say is it's probably more complicated than it needs to be, but on the other hand, they don't want to let the jury make up their own definitions for things or come up with their own way of doing things. They want the jury to follow what the law is, which is what the legislature of that particular jurisdiction has passed. And so the jury instructions are a way of transmitting what the law is in a basic, applicable form to the facts of the case in issue. Now, in addition to the jury instructions, there was some legal arguments on this let's go into the firearm charge. Now, this was count 6, and I'll just pull it up here. And it says possession of a dangerous weapon by a person under 18. And if you look at the code section that they cite, it's Wisconsin Code, sorry for the wobbly camera, Wisconsin Code section 948.60. And if you pull that section up and you go to, let's see, 60.2a. Here we are. So it says the title is Possession of a Dangerous Weapon by a Person Under 18. And it defines dangerous weapon. There's no real dispute that a AR-15 is a dangerous weapon, so I won't go into that. But it says any person under 18 who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. So there's not a lot of dispute that he possessed or went armed with the dangerous weapon. He's certainly under 18 at this time, Rittenhouse. And it's definitely a dangerous weapon. So what gives? Why did the judge dismiss this charge? Well, the answer is that there's an exception. And basically, the exception is, it says this section does not apply to a person under 18 who possesses or is armed with a dangerous weapon when the dangerous weapon is being used in target practice under the supervision of an adult or in the course of instruction in a traditional and proper use of dangerous weapon under the supervision of an adult. So this section does not apply to an adult who transfers dangerous weapon to a person under 18 for the purpose of target practice, etc., etc. And then it goes on to say, so that's the first. There's like 3 subsections that we're going to be dealing with. And we don't need to get into it too much, but I'll just summarize. The first subsection is target practice. Second subsection is if you're a member of the armed forces and you need your weapon for training or in the line of duty. And then the third section says this section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is in violation of, and then it cites a couple of other code sections, or is not in compliance with 2 other sections. So what are those other sections? Well, let me just make it real easy. The first section they cite is what's something called a short-barreled gun. This is a gun that's like a really short, easy to conceal rifle or shotgun. And then the second two sections that they cite are hunting. And it says restrictions on hunting or use of firearms by persons under 16 years of age. So to boil this down, and it is a confusingly written law, but it says, 1, persons under the age of 18 cannot possess dangerous weapons. 2, and the 2 is important here, under the rubric of the second section that's relevant here are 3 exceptions. And those exceptions are 1, target practice, 2, military, 3, if you're in compliance with a series of referenced hunting regulations. So, to summarize that, basically you have to follow the hunting regulations, and it also can't be a short-barreled rifle or shotgun. And you can't be under 16 altogether. So, the problem is, it's not 100% clear how you would apply that. Do you apply it only to the section the subsection that we're in, section 3? I mentioned there are 2 sections. Section 1 is the definition of the weapon. Section 2 says you can't possess a weapon if you're under 18. And Section 3, here's the exceptions for when you're under 18. And the problem is that if you apply the third one, the hunting one, across the board and just say anybody under 18 who possesses a rifle or shotgun, not hunting, but just in general, as long as it's not a short-barreled gun, if you apply that to everybody, then the result is that everybody in the state of Wisconsin under 18 can have a gun as long as the barrel's not too short. And that's clearly not what the Wisconsin legislature meant. So, it's complicated and it's a little bit frustrating, but it's also, it's just kind of one of those things that lawyers do, is we have to figure out what these mean. Now I'm going to pull up probably the most concise description of what is going on here with the hunting thing, or with the thing. So, somebody on my Facebook commented, they said, the judge skipped the first exception, minors can use firearms for hunting, and applied the second exception to the original law, effectively deleting the first exception altogether. So what was, minors can only use guns for hunting, and even then only if it's not on this list of prohibited guns. It's now minors can use guns as long as it's not on this list of prohibited guns. And that's exactly what the judge did. The judge just completely squished these things together and basically applied this exception to an exception to the original law, which was wrong in my opinion, although I, in fairness, can understand how this statute is a little bit complicated, and I think the legislature probably needs to look at that. Now, there's this thing called the rule of lenity, and the judge, of course, this judge is not very good, but he didn't mention the name of this principle, but he did talk about the underlying logic of this principle. And it says anytime you have a criminal statute that is unclear or purports to reach farther than it clearly does, you should apply this rule of lenity to construe the statute strictly in favor of the defendant. So in other words, you give leeway to people if they can't understand the statute. And while I understand that, I still think it's a sufficiently learned person can read through the statute and understand what the intent of the legislature was and how these sections fit together properly. And that is that the Wisconsin legislature wanted to make sure minors weren't walking around armed to the teeth. So they said minors can't have guns, but they wanted to allow minors to continue hunting. So they said, but you can hunt if you use your gun for hunting or target practice. And then they said, but if you're going to do this, you can't do these types of dangerous guns. And so that leaves, I think everybody would agree, it's not really disputed, that if Kyle Rittenhouse had been hunting with his AR-15, he would be an idiot and a bad shot, probably, because you don't go hunting with a 30-round magazine and a semi-automatic military-style assault rifle. That's not how you hunt. But secondly, so everybody would agree that if he was hunting, he would be protected under this exception. Or if he was target practicing, he'd be protected as well. And everybody would agree that if he had been armed with one of these more commonly understood to be illegal types of guns, like a sawed-off shotgun or a short-barreled rifle, everybody agrees he'd be subject to that law then. So the only question is, what about if you have a not inherently illegal gun and you are not hunting? What then? And the answer to me is clear. You can't. You're prohibited. But the judge saw it differently, and the judge ruled against the position that I would take on that. And I thought that was an astonishingly bad ruling, and nobody can really appeal it now because it could come up on an appeal as a side issue, but because it's not part of the jury's consideration, that is not going to be something that gets decided, which means you can't appeal something that doesn't get decided, generally speaking. So anyway, point of all that is that Rittenhouse is out of the misdemeanor charge. He now only faces the 5 remaining charges, and those charges are 2 counts of reckless endangering of public safety or of safety, 1 count of attempted first-degree murder, and 1 count of actual first-degree murder and intentional murder. We've talked about those in the past. Okay, so what about the lesser includeds? Well, the judge, and I didn't watch the whole thing, so I don't have a photographic memory of exactly what the judge ruled per count, but I know for a fact that he ruled at least 2 of these would have lesser included. I think it was the intentional homicide one. So I think he basically said, if you find that Rittenhouse killed somebody, but he wasn't acting with the purpose of killing them, intentional, but you still find that he was reckless, then you can convict him of a lesser included type of homicide called reckless homicide or reckless homicide. And if you still don't find he was reckless, then you should acquit him. Basically, it's something like that. There's kind of a sequence that they would have to consider. I don't think they included some more basic ones that might get included in a state like Iowa, where you have to include the lesser included offenses. But, in general, it's good to have options, because I think this jury in particular is primed to, if they're going to convict Rittenhouse, it's going to be on some sort of compromise. And thus, it's good to have options for the jury to land on, in my opinion. All right. So that's the lesser included offenses. And again, it's common. It's something that defense attorneys have to deal with all the time. All right. What is the law? Okay, I do want to, actually, before I get to questions, I have about 6 or 7 questions that I wrote down that people asked me. But I wanted to briefly go over the closing arguments first. Closing arguments are one of the most important parts of the jury trial. I think in this case, they're actually going to be the third most important part of the whole thing. The first most important part was jury selection itself, and the second most important part is the jury instructions, in my opinion. But the third most important thing is the closings. The closings are basically, here's what happened in trial, here's why you should vote a certain way. It's the summary of everything that happened and the persuasive argumentation from the lawyers about why they should go one direction or another. The closing arguments were really interesting, and actually when I woke up this morning, I was pretty pessimistic about the chances of Rittenhouse being convicted of much, if anything. I still thought he'd be convicted of that misdemeanor gun charge when I woke up this morning, and that maybe one of the reckless counts or something like that. After listening to closing arguments, I think that the state did a fantastic job on closing arguments. The attorney Binger was very, very good. He was very good at closing. It was like very well crafted and rehearsed, and it was just a really good closing argument. It was very persuasive. He called Rittenhouse a liar a whole bunch of times, which is true. He lied about a lot of stuff in this case. By the way, I'm not a huge fan of prosecutors calling defendants liars. I think that is somewhat, some you can imagine an an unsophisticated prosecutor getting a jury to go along with their bad case just by hammering home that the defendant's a liar a whole bunch of times. And I don't like that at all. I do think you have to maybe do that sparingly, and if you're going to use the word liar, do it only very specifically when the evidence clearly showed that. And I think the prosecutor did a good job with that, but I'm just saying that in general I don't like that. The prosecutor absolutely just eviscerated some of these talking points that you hear in right-wing discourse about this case, especially like on YouTube channels. By the way, I haven't mentioned this yet, but if you're listening to a YouTube channel or a right-wing commentator like Drew Hernandez, the witness, or whatever your crazy Nazi propaganda you're listening to somewhere, if they're not talking about provocation and defining it in the law, or if they're not talking about recklessness, or if they're not talking about these subsections of the firearm law, and they just say, well, yeah, of course he dismissed it. It's legal to have a gun, don't you know? Well, then you're listening to a trash source of information, and you need to change your source of information right away. We live in a country where laws dictate how we function. And some guy who doesn't even read the law, who's just having an opinion over here on YouTube somewhere on the horrible corners of the internet, if they're linking their stream to Rumble, that's a bad sign, okay? You probably need to click out of that one. If they have like a panel of libertarian commentators or something, that is not a great source of information. Libertarians are absolutely crazy. Probably should look at a different source of information. Probably want to find somebody who actually reads the law and actually cites it when they make a statement. Anyway, so the closing was very good by the state. Excellent use of the video, very just tightly choreographed and put together nicely. He made great points. I'm telling you, if I were on that jury and I listened to the state's closing argument, I would have been fairly convinced. I'm not sure that I would vote to convict on the top charge of all 6 counts or all 5 counts now. But boy, I'd be convicting a lot. I'd be putting a lot of convictions up on this case. Anyway, on the other side of the coin was the defense closing. The defense closing was unprofessional, personal. There was a lot of like ad hominem attacks, not on the case, which is what you normally do, but on the prosecutor. Basically, it was just a mess. I mean, they were all over the place. There was not a lot of organization. To me, what it looked like, honestly, and I've seen this a lot of times, it looked like a disorganized, tired, overconfident attorney who thought, oh, we've done our work on the case. We've basically won this thing. We've sewn it up. We've wrapped it up. I'll just wing it when maybe I'll write a few notes on an outline, but basically I'm just going to wing it. And I thought that was a really bad choice. First of all, there's no coherent theme whatsoever, so the jury's not going to remember 80% of what the guy said. They maybe remember a little bit here and a little bit there, but they're not going to remember the bulk of his very long closing argument. The state, there was a whole discussion about the length of closings, and the state had to push to make them 2.5 hours long each. And then the defense gets up and they're like, we're not even going to use hardly any. We're going to be really concise. And it's like, well, you just blew that promise. I mean, you completely, the defense was just as long, if not longer than the prosecutors, probably about the same length. But it felt so much longer. And why did it feel so much longer? Because it was disorganized. It wasn't easy to follow. It wasn't persuasive. It was a disorganized, off the cuff, stream of consciousness, very underplanned closing from the defense. And so, and like I said, I've seen it a million times. You just sat through days of trial. You've hardly gotten any sleep. You have gotten a lot of comments about how you're doing okay. You feel like you don't need to give it your last effort, and you just kind of phone it in. I've seen it a million times. And that's what happened here, I think. In the meantime, the prosecution clearly went home over the weekend and spent hours on this thing, getting everything lined up perfectly. probably rehearsing some of the verbiage, because he didn't stammer, he didn't stutter, he didn't have any sort of issues with his language or anything. He just basically said that he just said what he said, one line after the next, and it was very polished and it was very persuasive, like I said. Now, one other huge tactical thing that I want to talk about, well, there's two actually. One is that the defense attorney actually said he was glad Kyle Rittenhouse shot Mr. Rosenbaum in the middle of closing. First of all, I mean, just going back to law school, that's something they teach us not to do. I mean, don't pile on to somebody who's lost their life. Don't pile on to a victim, even if it's necessary to criticize or undermine the credibility of a victim witness. You don't want to seem like you're attacking them. You don't want to seem like you're being mean, I guess. And so when the defense attorney said he was glad that Rittenhouse shot Rosenbaum, because if he hadn't, then Rosenbaum would have gotten his gun and shot. Well, first of all, the second part of that is foolish, and I'll get into that in a second. But the first part of that is just so crass and thoughtless and compassionless for Mr. Rosenbaum and his family that I thought that probably turned a lot of jurors off. We'll see. The other strategy issue that I want to mention is that the defense really, to the extent that I could follow it and try to figure out what their overall message was, I thought that they were really trying to push their narrative of events. And you might think to yourself, well, of course they were. That's the whole point. The prosecution makes their case, and the defense makes their case, and then the jury decides. No. That is not how our system works, and that is a horrible strategy, because you, as a defense attorney, as a defendant, you have this massive advantage. The state has other advantages. The state has a lot of resources. They get to decide who gets charged. They have a tendency to have all these police officer witnesses that the jury likes, et cetera, et cetera. But the defense has a huge advantage too, and you know what it is? It's the burden of proof. They sit there and they're presumed innocent until proven guilty, rightly so. And the state has to prove them guilty beyond a reasonable doubt. And like I said earlier, that's not just like a generic gloss over concept. That means that on every single count, all 5 of the remaining counts, each element, each count has to be absolutely proven beyond a reasonable doubt, meaning the state has to disprove every reasonable alternative hypothesis. I think the defense attorney spent less than 30 seconds pointing this out. He did reference it like once or twice, but it was just glossed over. He spent the entire time trying to reframe everything and narrate the events of the evening in a way that, frankly, I don't believe, making it seem like Rittenhouse was a member of this community. He's not. That he wasn't really lying because he's a lifeguard, so his EMT lie wasn't really a lie. Well, that's a lie. That he was legally authorized to go around with his gun and point it at people. He wasn't. That he never pointed at anybody. He did. That he didn't admit to pointing at anybody. He did. That there isn't video showing him pointing at people. There is. Just detail after detail that the defense tried to construct into their narrative of what happened that were pretty easy to disprove, I thought, and the state preemptively and then subsequently disproved most of those points. So I guess what I'm saying is that by setting up an alternative narrative than the state's case, the defense is, although not legally doing so, they are sort of practically creating their own burden of proof. Even though they have none, they don't have a burden of proof. But by saying, this is how it happened, jury, this is what happened, it went down like this, he didn't do anything wrong, I'm glad he shot the guy. By doing all that, they're kind of setting themselves up to look bad, because their case, as it were, they don't have to have a case, but their case is just as vulnerable as anybody else's would be. The dog's barking. And so basically, by setting up this alternative narrative only to be subject to disapproval by the state, my dog's barking. By doing that, they are ceding this advantage that they have of reasonable doubt, and they're basically saying, well, don't believe their narrative, believe our narrative. And then what if the jury does believe the state's narrative, but not by enough to be convinced beyond a reasonable doubt? Well, normally the defense attorney would be like, well, even if you believe 90% of what they're saying, you need to... Hold on one second. Okay, sorry about that. Anyway, so they set up these dueling narratives. It shifts the burden in a subtle and not real way, but in a way that the jury actually might get confused by. And what you end up with is, what if the jury doesn't believe the defense theory of the case? Well, then the defense has made a commitment that they haven't lived up to. And so now the jury doesn't trust the defense. And now the jury doesn't take that proof beyond reasonable doubt thing seriously because they don't trust the defense, and the defense is wrong about all of this stuff, so the state must be right by contrast. That's essentially what happens, and that is why it's a horrible tactical move in defense trials, in criminal trials, for the defense to do that. You don't want to set up a counter-narrative, hardly ever. I mean, you definitely want to have a counter-narrative, but you don't want to set it up as something that definitely was the case. What you want to do is you want to say, the state has to prove X, Y, and Z. And because of some evidence of W, I'm trying to think of the letter before X, because of this W evidence, X, Y, and Z aren't proved. You don't want to say, the state has got to prove X, Y, and Z, and we've got to prove Q, R, S, and have a dueling thing like that. You want to keep the state as the only person who ever has to prove anything, and just point to your narrative here and there to poke holes in the state's lack of proof. It was a huge tactical error for the defense to do this, and so when you compare the very well-polished, very persuasive, and really logically sound case that the prosecutor made against the rambling, incoherent, long-winded, and tactically unsound closing that the defense presented, you really get I think it shifted the grounds a little bit for what's going to happen. So that's the closings. The closings finished today. They took at least a full 5 hours, if not longer. The judge actually, despite dismissing the firearm charge, other than that, was fairly reasonable today, which is literally the first day of this entire thing. I can say that. So maybe he heard some feedback over the weekend or something and he was getting criticized. I don't know. But, all right, let's go over some questions, and then I'll conclude with a final thought here. All right, first question, what do I think is going to happen? I get this question a lot. Well, honestly, I think that the most likely outcome, and I've been saying this for days, if not weeks now, I think the most likely outcome is something called a hung jury. Now, hung jury is basically when you have 12 people who at least one of them doesn't agree with everybody else. So there's at least two sources of different, conflicting decisions being made by different people on the jury, and it has to be at least one person. So it can be 11-1, or it can be 6-6. It doesn't really matter. And then the judge is going to say, well, you need to work through that, figure out what you can all come to an agreement on, work to build consensus, etc. And after a day or two of doing that, and if they're still not moving anywhere, if there's no shifting, then the judge will say, well, you're hopelessly deadlocked, and declare a mistrial. That's called a hung jury. It's not uncommon at all. It's especially risky here, in my opinion, and I've said this, because we live in a very polarized society. This case basically is a polarized microcosm of our society. And therefore, if you get a single juror from a rigid political position who is sitting there going against what everybody else is working through, I think there's let's break it down into three types of potential jurors here. There's the die-hard conservative gun rights fanatic who won't convict anybody on anything to do with a gun charge, especially a white person, even if their life depended on it, okay? Then I suppose on the other end of the spectrum, you'd have sort of the radical liberal who would just blindly vote to convict somebody no matter what. And I don't think that type of person actually exists, and I'll explain why. But then you have the average juror, which is somebody who sincerely wanted to work through the evidence and come up with a result that accurately reflects what happens, okay? So let's say you got 10 of those people and you got 2 conservative diehards. Well, then several things could happen there. The conservatives could hold out, and the other people could work through that and come to a conclusion: we need to convict on count 1 and 2, but not 3, 4, and 5 or whatever. And then you get a hung jury between those 2 positions, and then the diehards never move. You could get a compromise where the 10 people work through it and they say, we want to convict on all 5 counts, and the diehards are like, oh no you don't, we're not going to change our position. And then they say, well, what if we all just agreed to put our differences aside and convict on count 1, and then let everything else go, or whatever. That's called a compromise verdict. It's technically not supposed to happen in a criminal case, but a lot of the times you don't know that, and sometimes compromise can be the result of kind of going through which charges are the most convincing, which ones are the least convincing. And so the compromise is not so much as can you give it to me for $1 less, merchant? It's not like a haggling situation. In other words, it's do you like my example of a merchant transaction? That's how I buy things, by the way. I go to the grocery store and I'm like, could you please give this to me for $1 less, merchant? Anyway, it's not like that. I mean, and it could be like that. I mean, maybe we would never know if it was. But a lot of the times it's more like, well, I'm really strong. I feel strongly about this. You feel strongly about that. So I will give your thoughts some weight in this discussion, and maybe you can give my thoughts some weight, and we'll come to a consensus that works for both of us. I mean, that kind of thing happens all the time. It's kind of what juries are supposed to do. And as long as everybody kind of works through it in their mind and comes to be okay and comfortable with that result, then it happens. So that is called a compromise verdict. I think that is possible if you have the 10 and the 2, let's say, and then you have the possibility that the 2 will just stubbornly dig in and never vote to convict. So you either have the compromise verdict or the hung jury possibility. Now, if there's no ideologues on the jury and it's just 12 random people who are sincerely and not preconceivedly working through the issues, I legitimately think there's a decent chance of a pretty high conviction. I think he might get convicted on several counts. But I have no confidence that there's 12 people who are of that kind of open mind. By the way, earlier I mentioned that there's probably not like a liberal who's a diehard gun opponent who wants to convict no matter what. I'll tell you why. Because that's in conflict with another liberal value, which is due process for the accused. Here we have a child, literally somebody under the age of 18, who was charged by the state of Wisconsin for very serious criminal offenses. What he did was despicable, and some of his social media and stuff where he hangs out with these bad people and stuff, I don't like it at all. But I'm a liberal at the end of the day, and I don't want anybody, from Osama bin Laden to a petty thief, to ever see the inside of a jail cell until they get due process. And so I think a lot of liberals share that view and are much more pragmatic about these things, and they think, yeah, I don't like guns, but I'm going to look and see if this guy did anything wrong before I vote to convict him. I think it's a liberal value to give people accused of crime thoughtful consideration before convicting them in a criminal court. So I really don't think there's a lot of diehard liberals who vote to convict no matter what. Usually the stereotype is that liberals are the type of people who vote to acquit on juries, and conservatives are the types that vote to convict. So it's kind of shaking that up a little bit, and the conservatives would be the diehards in this case, and the liberals would actually be not diehard at all. So it's weird how that works out in this case. But if there aren't ideologues on the jury, it could be a full conviction or it could be a straight acquittal. Who knows? Very difficult to predict. But if there's a stalwart conservative on the panel, which I suspect there is, just statistically in Kenosha, it's a purple state, and it's kind of a purple swing city in that state. It's a swingy area. Because of that, I think just statistically it's very likely that there's at least one diehard conservative on the panel, which means that it's going to be hard to get through the 5 remaining counts in a fair and objective way that doesn't involve placating this conservative somehow, whether it's compromising or Maybe he won't budge at all and there'll be a mistrial. Who knows? So that is what I think is going to happen. I think the most likely result is a hung jury. I think the second most likely result is a compromise conviction on maybe a reckless endangerment charge or something like that. I think the third most likely result, I guess, I'm still probably leaning towards an acquittal. And then I think the fourth most likely result is a across-the-board conviction. So, I think this was a hard case to begin with, but I think the prosecutor has actually done an admirable job getting it to the point where there's a serious chance of a full conviction. And the fact that I think it's the fourth most likely thing doesn't mean that I think it's unlikely. It just means those percentages might be like 35, 25, 20, and 15, or I don't know what the math is on that. Those are all viable possibilities, and I just happen to think that the most likely is a hung jury. I think the second most likely is a compromise verdict on a by the way, if he gets convicted of even one of the remaining counts, no matter whether it's the full charge or the lesser included, he will be a felon. He will never be able to carry a gun again. That is 18 United States Code, Section 922G, for anybody who's interested. Next question. What is the law with regard to minors and guns in Wisconsin? I actually already answered that. That is the whole thing about generally prohibited except for hunting, but then when you're hunting, even when you're hunting, you can't have certain types of guns, but the judge applied the gun restriction language to the general law and said, if you're under 18, you can't have certain types of guns. Instead, when you're hunting, you have certain types of guns. In my opinion, the judge was wrong, but that's what the law is in Wisconsin. In my opinion, the law in Wisconsin generally prohibits minors from carrying weapons, absent one of the exceptions, and I don't think the exception applies here. Next question. Do all the jurors have to agree on all the counts, or can they agree on some of them? Oh, that's a good question. So what if they have a unanimous decision on count 1 and 5? Let's say they vote to acquit on counts 1 and 5, but then they're divided on counts 2, 3, and 4. Well, the judge will continue to press them to make a final decision on counts 2, 3, and 4. And he'll say, well, keep working at it, keep trying, work to build consensus, et cetera, et cetera. And if the jury remains deadlocked as to those counts, then this gets a little bit complicated. In general, that's still a mistrial. That's still a hung jury. However, I have seen situations, and I've actually had a trial once, where the parties agreed to, quote, take the verdict on the resolved counts, unquote. And then we took a verdict, and the counts where the jury wasn't in agreement were just dismissed, and then the ones where they were in agreement, we got the person was found guilty on. So basically, that can happen. I don't know the law in Wisconsin well enough to know if that's a viable procedure, but in general, if even one count remains unagreed to, then it's still a deadlock. It's still a hung jury until there's agreement. And you can sometimes wiggle your way through that in a different procedural way, but in general, that would result in a hung jury and a mistrial. If they agree, but I think the other possibility there is if they agree on a couple of the counts, but they're not in agreement on some of the other counts, then eventually some of those jurors on the other counts might give up their position and say, fine, we'll acquit on that if we convict on that. That's the sort of compromise verdict I mentioned earlier. So that's possible as well. All right. Next question. How long do you think it will take? That's also a good question. I think this will probably take a full day for the jury to deliberate. I don't think they're going to want to stay longer than the day. So I think they're going to be really incentivized to go through the day. Tuesday, what we'll start seeing probably is jury questions. The jury will have a big set of instructions and a bunch of exhibits, but they will inevitably come up with a question like, well, what if we think that he was scared for his life, but that the person really didn't pose a threat to his life? They'll come up with a question like that. And then the judge and the attorneys have to find a way to answer that question. It's kind of funny because you can't really answer those questions. You have to find the place in the instructions where there is an answer to those questions and basically repeat that back to the jury. So, that's quite possible. We'll see those jury questions trickle in. I think the jury will try to have a decision by the end of the day tomorrow. It is possible, by the way, if there is a lot of agreement in the room about this is a bad case, this is a weak case, it's possible you'll see an acquittal. Shorter than that, acquittals generally, okay, so the conventional wisdom is the shorter amount of time the jury deliberates, the more likely there is for a conviction. The longer it takes, the more they're struggling with it, which means that the defense is having a good time. And so that might not be the case here, because a lot of commentators, especially on the right, think that this is a slam dunk win for the defense. And who knows, maybe it is. If it is, then it could be that a short deliberation means an early acquittal. But the dynamic that I think we should be paying attention to is that if it starts taking a long time, and usually when I say, let me back up. This is a complicated murder trial, a serious trial. It's not a simple theft case, so we should expect the jury to take a little while anyway. I would say any verdict on this case within 4 hours is relatively short. Anything longer than that is starting to get into the longer territory. Maybe 3 or 4 hours is kind of that middle ground where you might expect something to happen. And so anything after starting at about the 4th hour, into the 5th hour is starting to get on the longer side. Anything kind of shorter than the 3. Let's say 1 to 3 hours is short, 3 to 5 hours is, middle range, and then anything longer than that is longer. If you start seeing it go into that middle to long range, then I think what you're seeing is that there is somebody, at least one person on the jury panel, who is dead set against forming a consensus with everybody else. Maybe one of these conservatives or something. And so you might look out for that. The longer it goes, the more likely it is you'll see a hung jury, or the more likely it is there's some sort of profound disagreement that's holding the jury back from making a decision. But I do think they'll try to have an answer within 1 day, and I personally think it will take 4 hours or longer to make that decision. So I don't think it'll be until the afternoon that we know anything. And even then, if there is a holdout, what you're going to see is these jury questions start coming in. Well, what if 11 of us agree and one of us doesn't? What if we agree on 3 of them but not 2 counts or something? Then, eventually the judge is just there's something called an Anderson charge, which the judge can read, that really encourages the jury to work together to find a verdict. And then, if it starts taking 5, 6, 7 hours, that probably means they're going to have to go into a second day of deliberation. And usually the judge won't let juries remain deadlocked for more than like 2 or 3 days. So if we see it take all day tomorrow, and then we start out on Wednesday and it's taking all day on Wednesday, and the jury comes back with a statement that says we cannot reach a decision, we're deadlocked, it's possible the judge would call the mistrial on Wednesday. Some judges might wait until Thursday to do that, but that's kind of the time frame. I think it's very likely we'll have some idea of where this is going by tomorrow, but if it is going to be a hung jury, I think that will actually play itself out on Wednesday. Next question. What if the jury thought he was in fear for his life, but they still think he was not reasonable in that belief? Okay. Yeah, that's a good question. So what if they think he personally was in fear for his life, but they also think he was kind of putting it on himself and he's kind of full of it? Well, that's an interesting quandary that comes up a lot in the law, and that's something called imperfect self-defense. What that means is that you don't quite meet the qualifications for self-defense, but it also means the jury has found some facts that make the state's argument about intentional murder invalid. Intentional murder can be reduced in seriousness to manslaughter in a lot of states, or in, I think, Wisconsin, it's probably would be reduced to reckless homicide, which is kind of like manslaughter, so it's kind of an analog to manslaughter. So if you actually subjectively believe that you're about to die and you kill somebody, but the jury finds you're unreasonable, you're out of murder. You're out of murder 1, and at traditional murder hierarchy, you're down to manslaughter. I think in Wisconsin, you're probably down to reckless homicide. You're still probably going to be, if they follow the instructions, you'd still be guilty of that lesser included offense. And you could still be sentenced to prison for this sort of manslaughter type of reckless homicide thing. But That's called imperfect self-defense, and it would reduce a charge of murder to manslaughter, in this case, intentional murder to reckless homicide, if the jury found that the person subjectively believed that they were about to die, but didn't believe that was reasonable. That's a serious possibility too. You never know. If they did that on the reckless homicide charge, I'd have to look up the particulars, but in general, if you did that with manslaughter, you'd still be guilty of manslaughter. So in other words, if you're charged with manslaughter and you have imperfect self-defense, that doesn't get you any lower. It just takes you down from murder 1 to manslaughter. So I'd have to look at the Wisconsin law to know this for sure, but my guess would be that it wouldn't excuse anybody from reckless homicide. It would just take them from murder 1 down to reckless homicide, and it would just keep them at reckless homicide as sort of like a floor. Could be wrong about that though. The elements might be a little different in Wisconsin, and maybe it would take them down to something even lower. I don't exactly know, but my hunch is that it would keep them at reckless homicide. I'd have to look further to know for sure. And if that is possible. If the jury doesn't think the self-defense was reasonable, then he's going to get convicted of something, and it might just reduce a couple of those more serious charges down to something a little bit less serious. All right, next question. What can the state do if they don't think they got a fair trial? Okay, so this has come up in my last video and on Facebook a lot. The state doesn't have the ability to appeal most things. They can appeal pretrial rulings in a expedited pretrial appeal, but we're already at the point of trial, so that's not a relevant possibility right now. If there's a procedural issue that occurs that resolves this case, let's say the judge dismisses the case, or if there's a mistrial and then there's some sort of dismissal after that, or if there's some sort of ruling that's procedural that prevents the jury from making a decision on the case, then the state might have some appeal options, because the only time the state can't appeal something is if there's an acquittal. So if the jury makes a decision and it's anything other than a conviction, so basically an acquittal, the state cannot appeal that because of double jeopardy. The person has already been held in jeopardy, and you can't put them back on trial for the same thing. Even though there might have been a flaw in the legal proceedings, they still get the benefit of that acquittal, and they can't be put back in jeopardy under the Fifth Amendment of the United States Constitution. However, if they are let off on a technicality, or if there's some other ruling by the judge that resolves the case without the jury making its decision, then oftentimes those can be appealed by either party, and that doesn't necessarily have double jeopardy implications unless, as came up earlier in the trial, the judge thinks the prosecutor did something that is being appealed on purpose to prevent having an acquittal, to avoid a double jeopardy issue. If there is a guilty conviction, then the defense can obviously appeal that. The state really wouldn't appeal that. There's something called a cross appeal, where the state could file its own appeal if the defense appealed, but they couldn't ever get a conviction if there's an acquittal, or if there's a finding of a lesser included, let's say. They could never get that top charge back, even if they appeal. So once the jury decides something, it's kind of like a one-way ratchet. It can't ever go more serious than the jury decides. And so the state's options for appeal are very limited. There are some appeals that the state can do that would never subject the defendant to jeopardy again, but they might appeal it anyway to clarify the ruling. That happens in some states, but in general, the state's remedies are pretty few and far between as a state. There's another question that's going to get into some federal stuff that I might have one little wrinkle that goes into that. The next question, though, before we get there, is, will this lead to people in the future doing what Rittenhouse did? Yeah, so that's a good question. I think that a acquittal will empower gun militia people, and a conviction will enrage them. An acquittal will enrage people more on the left, might inspire some more protests and riots, might help Democrats politically in the coming election. A conviction, I'm convinced, would help Republicans in the next election. I think they would try to trumpet this case as travesty of justice. So it's kind of like one of those damned if you do, damned if you don't things. One thing I will say is that for the purpose of deterrence, even being charged with murder and being put in prison or jail, with a very, very expensive bond and having to hire these lawyers and having to spend weeks of your life stressing out about a life or death, essentially a decision that could affect the rest of your life like this, that alone is a deterrent to people breaking the law. I think one thing that I tell people a lot that prosecutors sometimes don't even realize is the mere act of being suspected and charged with a crime has a significant deterrent effect on people if they are not criminally hardened, because it's very stressful to get charged with a crime, even if you're ultimately found not guilty at trial or they dismiss it. So I think there's still some value to this prosecution, even if it doesn't succeed. However, obviously, if he's acquitted, there will be celebrations by people on the right. They will feel free to march around with guns and provoke people and to kill them. And I really worry about the long-term consequences of a decision of that nature. So to answer the question, I do think this will lead to people in the future following suit and getting themselves into positions where the traditional law, going back hundreds of years, said they are not protected, but because of the political issues in this case, they're trying to make the law into what they think it should be. And unfortunately, if they get enough people in our society to start thinking that way, then people won't get convicted of this, except in liberal places, which, that's important, but it's still very troubling, especially in a swing state, to see this empowered militia culture. I think that's a bad thing. Next question, what if he gets off on a lesser charge? Will he still go to prison? We talked about the consequences for the charges the other day. Count 1, reckless homicide is up to 60 years plus a five-year addition for dangerous weapon. Reckless endangering public safety is up to 12 and a half years with a possibility of a 5-year addition for use of dangerous weapon. Intentional homicide is life. Attempted intentional homicide is 60 years. And then the misdemeanor was 9 months, but that's dismissed. So, yeah, if he gets convicted of reckless homicide or even reckless endangering public safety, he's still looking at, certainly it's a felony, and then secondly, it's at least a decade in prison max, plus, so it could be 17 and a half years for reckless endangerment, could be 65 years for reckless murder, reckless homicide. For intentional homicide, it could be life. And the thing is, he has no criminal record, he's young. A sentencing judge would probably send him to prison if there was a finding that he had killed somebody, so a reckless homicide or intentional homicide. For reckless endangering safety, however, I would actually expect, even though it's a Class F felony, punishable by not more than $25,000 and 12 and a half years in jail or in prison, I would expect the judge in that situation, if unless there's a mandatory minimum, which I'm not aware of, but I would actually think that a probationary sentence would be a possibility there. And actually, as somebody who does this or did this exact thing for many years, I have to tell you that if he's only convicted of reckless endangering of public safety, I would not be outraged by following that particular sentence, even though I think he deserves to go to prison in general. I think that if he's acquitted on anything to do with killing somebody, he's just found guilty on threatening the safety of people, then I think probation is probably the right thing. Don't misconstrue me, though. I think he deserves to go to prison for killing people. I just think that if he gets off on killing the people and is only found guilty of the reckless endangerment, that probation is probably appropriate. And, the other thing to mention here is that it's a felony, and he would not be able to have guns anymore. And also, from personal experience, if somebody is on probation, they tend to not be a reckless criminal person, or at least unless they're addicted to drugs or something. I mean, if you have the choice, if you're not destitute and addicted to drugs and these things that people can't control criminal behavior with, it would be very bad if he was on probation and he went out and started shooting more people in the next protest, because he would not only get his probation violated, which is really easy to prove, he'd go to prison for that, but he would also have this record now that he's built, and that would be used in his next case to give him a harsher penalty. Somebody's criminal record is a very substantial factor in how serious their punishment is for a criminal offense. So I think that if he gets off on a lesser charge of his reckless homicide, I think he still will go to prison. But if it's reckless endangering of public safety, I don't think he will go to prison. Last question that I have is, what is the federal angle on all of this? What about the mother who who brought him across state lines, and what about buying the gun across state lines? Well, first of all, the gun purchase itself was definitely illegal. I believe there's some prosecutions pending about that in Wisconsin. But in terms of answering the federal question issue, there's something called the Petite policy, or Pettit policy, I'm not really sure, that everybody should look up. But basically what this policy is, even though we think of double jeopardy as precluding being prosecuted for the same offense twice, and it does that, it only does that with respect to a given sovereign. And in the United States, each state is its own sovereign. So in other words, the state of Iowa could not prosecute a person twice for the same thing. But there's nothing in our Constitution, and there have been cases about this, that says that another state couldn't prosecute somebody for something, or that the feds couldn't come in and prosecute for something, even if part of it happened in Iowa or all of it happened in Iowa, just because Iowa prosecuted before. So the double jeopardy thing doesn't apply in cases where different governments are coming in to do the prosecution. You can have somebody get convicted of murder in Iowa, and then the federal government could constitutionally come in and charge them with some sort of federal terrorism resulting in death charge that's essentially murder but on a higher scale or whatever. And so what happened is the federal government came up with a policy that has been followed for, I don't know, decades, if not, well, I think, okay, I'm looking at it now. It's 1939. So it's been actually, that's not right. 1959, okay. And 60 was the Pettit case. So it's been in place for 71 years now. And this policy basically says that the federal government will only prosecute in situations where the state prosecution is not adequately representing federal interests and wouldn't result in an injustice, and there's a few other factors that they consider. Basically, they are dissuaded from prosecuting run-of-the-mill cases when the states got it, and they will typically only prosecute what would normally be a state issue if there is a strong federal interest and the state doesn't appear to be handling it sufficient to meet the federal government's needs, and it wouldn't be an injustice to do so. So here's the deal. Kyle Rittenhouse will almost certainly not be prosecuted federally if he's acquitted in state court. He was a 17-year-old at the time he committed his crimes. However, I think there's a strong possibility that people involved in the false purchase of the gun could be prosecuted. His mother certainly could be prosecuted federally or at the state level. I'm not sure that they'll go after her. I kind of have mixed feelings about that. I think in the perfect world they would, but the right wing is going to use that as such a punching bag that I wonder if that's more harmful than useful. But I definitely think there should be other people involved in this situation should be looked at, because I think that they were just as responsible for what happened as Rittenhouse was in some ways. So yeah, the point is there could be a federal prosecution. They could technically prosecute Rittenhouse even if he's acquitted. I don't think it's likely they will. The federal government does not like to prosecute people under 18. But I think it's more possible that they would prosecute people involved with the straw purchase of his AR-15, or prosecute his mother or somebody who assisted him in getting over state lines to commit this offense. I also think that if Rittenhouse is convicted of one of the felonies and does something bad in the future, he will be federally prosecuted for, if he uses a firearm, for felon in possession of a firearm under 18 U.S.C. 922G. Okay, so that is the end of questions. I just wanted to wrap up by saying that This case has been really interesting, and thank you so much for everybody who's had feedback and talked about it. And it's a lot of people are following it. It's a riveting case. Why is it so interesting? Well, the answer is I think it's a referendum. Oh, you know what? Before I get to this lofty discussion, I wanted to mention one more thing about the jury instructions. There was a big fight, a very important fight, over this provocation instruction. I thought, based on how the judge was talking about it, that the defense was going to win that and get the provocation instruction thrown out, but actually the state won that. Provocation, as we mentioned in the last video, is this idea that you can't go around triggering people to fight you, and then when they fight you, you shoot them and you claim self-defense. Provocation extinguishes self-defense for a lot of purposes in general. And the state won that battle. They got the provocation instruction, and they used it so effectively in their closing. I thought that the whole sequence about, he went around with this gun pointing it at people, and that's really what caused all this trouble. All right, so I thought that was a really interesting thing, and a really good victory for the state, and probably one of those things that if he is convicted of something, we might go back and look at and say this might have been the moment when. So I just wanted to mention that. Okay, back to what I was saying. This case is a referendum in some ways on that very concept, on the issue of provocation, on the issue of what can people do to cause trouble before they're held accountable. I think a lot of people, when I was growing up, lived in a world where, if you want to have a gun, you should be a responsible gun owner and have gun safety training and keep it in a locked safe and maybe use it for hunting and target practice, but never go out looking for trouble with it. Maybe self-defense in the home, but don't go outside with it and walk around somebody else's property that you don't even know them on the pretext that you're defending their property. I mean, it's just insane. A lot of us grew up in that world. More and more as time has gone on, this alternative world has emerged in right-wing circles. This alternative world where there's a lot of bad people, there's a lot of criminals and thugs and etc. So we all need to be armed. We all need to have a gun. We all need to go around with our gun on our hip and be ready to stop a bad thing from happening at a moment's notice. They literally want a society where all the well-to-do, primarily white people have guns and they live in gated communities, and then all the people out there beyond the gates of their gated communities don't necessarily have guns, and to the extent that they do, the good people are entitled to shoot them and go around and provoke them even, and go around with their guns and taunt them, and when they respond as normal human beings would to being taunted with a gun, then shoot them. It's a very sad and sick world that some of those people want to live in, this sort of us versus them, everybody needs a gun world. I don't want to live in that world. I want to live in a world where life, no matter whose life it is respected. One of the lines that the prosecutor said at the very end is that, he was talking about these victims, Rosenbaum and McGinnis and Roskreutz and all these people. And, he was kind of acknowledging that the state had really gone hard, or that the defense had really gone hard to attack those victims. If this was a sexual assault case, there would be outcry about victim shaming. But I guess in murder cases, there's no real concern about victim shaming. Certainly isn't a national movement about it. But, he said this line, and I thought it was great. He said that, all life is important. He didn't say all life is sacred. He didn't make it into a religious spiel, but he said all life is important. All life has worth and value. And he's right. These people that, kind of countered the Black Lives Matter movement with the phrase, all lives matter. Well, guess who was shot in this case? There's 3 white people, or maybe 2 white people and a Jewish person. I'm not sure about Rosenbaum's ethnicity, but, they're not people of color in the traditional sense. And yet there is such utter disregard for these human beings who were killed in this case. And this is, not to get political, but there's a lot of slogans in right-wing politics about all life matters, all life is sacred, etc. But apparently that is a crock of bullshit, because they didn't give a damn about these lives that were needlessly ended in this case. Rittenhouse went around with a gun and started pointing it at people. He started going up to people, trying to be part of the action, trying to find places where exciting things are happening. He pretended to be a medic, got up in there and started pointing his gun at people. And you know what they did? Some of them tried to knock the gun out. Some of them rushed him and tried to grab the gun. Some of them probably tried to push him or move past him or something. They made movements toward him because their lives were threatened by him. He provoked them. And he shot them in response. And the defense, as the prosecutor pointed out, is very hypocritical, because they say Kyle Rittenhouse was entitled to use self-defense when other people provoked him. But weren't those people who are dead now, who can't testify, weren't they entitled to use self-defense when Kyle Rittenhouse provoked them? You know, when Kyle Rittenhouse pointed his gun at Mr. Rosenbaum, was he not entitled to respond with deadly force? Kyle Rittenhouse was pointing a loaded AR-15 with 30 rounds in the magazine. This gun has a unbelievably high velocity, muzzle velocity. It shoots these 223 rounds of ammunition that we've heard testimony about this full metal jacket. I've been told, I'm not a military veteran, but I've been told that these were designed to not immediately kill the victim, but to pass through the victim to do maximum damage and cause maximum battlefield confusion. Because if you have a bunch of people with severe injuries from these bullets, you basically incapacitate your opposition. Setting that aside, though, even so, when somebody points a military-style assault rifle with 30 rounds of ammunition that is literally used in war, or its equivalent, the M16, is used in war, are you not entitled to defend yourself? Are you not entitled to knock the weapon back or to punch the person? That's not even going to kill them. That's just going to, disorient them. Are you not entitled to defend yourself? Why is Kyle Rittenhouse the only person in this entire trial who's entitled to defend himself? Why weren't those victims entitled to do what they did in defending themselves, and then, Rittenhouse killed them? Why does the analysis only start halfway through? Rittenhouse points the gun, then they come at him. That's when the defense wants to start the analysis. They come at him. They ignore that first part, the provocation. And that's why it's so important that the state won that issue on the jury instructions, and that's why it's so important that the prosecution made a point of this in the closing, and that is why I say this case is a referendum on provocation and what people can do with guns to trigger people and get away with it. And that's one of the reasons why it's going to be tough for this jury to make a conclusive decision, as I've predicted, because there are so many different opinions about this in our society now that it's going to be hard to put that aside and just deal with the facts as they were presented at trial. I hope they will. I hope they will come down with a fair verdict that accurately reflects what happened and give justice to these victims. But even if that happens, it's not the end of the case, because I know that the right wing is going to use whatever happens, especially a conviction, as a rallying cry to pass even more ridiculous gun laws that allow people to, people who can't see to have guns, and people who are intellectually disabled to have guns, and to put guns in every classroom. They're going to use this as a method to get the most armed country on the planet, where we have more guns than people, even more heavily armed. And I fear for that country. That is not the country I grew up in, and that is not the society I want to live in. It makes me really sad that even a just result in this case will have those consequences down the road. So anyway, that is my video. Thank you so much for watching. I hope that answers a lot of questions. If anybody else has any other questions, feel free to post them on my Facebook or respond to this video on YouTube, and I would be happy to answer them. Thanks for watching.